Patterson. He's going to try and get his driver's license. He can take that license and then show us that the taillight is operational and everything.
How long do you need to do that? Months or 3 times or something. What I see here is 36 of people. And all of the cars. Quite cold.
Spoke with Mr. Claycomb. Been offering that he's going to complete a light at 25 and 32 hours of public service. This week he'll get permitted to offer. He's on a restricted license right now. It looks like if he's able to do all this, there's a chance to keep it. I spoke with Mr. Freeman. It was confirmed that his insurance was valid on the day of the offense, so he was missed in July. That leaves him speeding. He's going to plead guilty to 74 and 55 for one speeding.
So which means we think, yes, sir. Okay. $2,000 phone, the cost, it comes to $276.50. Towards the right, I think, is the tiger, and you,
We're here today on Mr. Davis's case for a motion hearing and a police cutoff case. There are 2 aspects to the motion. I understand one of them is uncontested by the district attorney. That was the aspect of the motion that requested suppression of statements made during the period of incompetency. If you recall, the court ordered that the DA produce whatever statements he's been to rely upon. He is not, and he's, I understand, not contesting that motion. So I understand that's no longer before us. The other motion is one that has got some factual implications to it. It seeks to suppress statements that were made by Ms. Davis after she was in custody, but before she was given Miranda rights. Disclosure reflects no Miranda rights were given, which leaves open the question of when she was in custody. I understand, if I can speak for him, Mr. Andrews takes the position that the motion was filed late, and as I understand, there was no specific cutoff date, but it's too late for him to make arrangements for law enforcement personnel to be present today, and he's going to object to the court hearing that motion. We've engaged in negotiations without.
so we're still planning on going to trial on 8/28, is that correct?
That's my expectation and my client's further desire.
I think I have some reservations in that I think there is a legitimate motion issue to be had. Obviously, at some point, Ms. Davis was taken into custody. She then spent a lengthy amount of time in jail and at the NHIP. So I don't think it's in dispute that at some point she was taken into custody. The issue is when she was taken into custody and what statements were made before and after that. My concern is that if we don't address that motion at some point simply because it was filed late and I didn't have sufficient notice, that sets up a pretty clear and effective assistance of counsel claim. So I'm a little bit weary of proceeding to trial with pursuing this motion just at all. But given the time frame that it was filed Thursday.
Let's understand how much time do you need to
Sure. I don't believe that I could be prepared to hear the motion next week and then the court's going on recess. I think I'll need likely 2 witnesses for it. I think it's mostly testimony based and not necessarily legal argument based. As the primary question is when she was actually in custody for the purposes of briefly reviewed it, I'm not sure if I would intend on filing an actual written response before that testimony, or if I just do the testimony, but regardless, I'm a little hesitant to say that I'll be ready to go on it in less than a week. Given that, I'd be asking to set a motions hearing at some point after that. I'm not sure if we'd be available to set a motions hearing and still have that trial date. That trial is the first week back after the court is admin.
Trial on August 31st or something.
That would be easy.
August 31st trial instead of August 28th trial.
I don't want to move that day. It's to my benefit not to move that day.
Wait till you see what your choices are.
I just need to advertise.
17M4. Oh, that's our case.
Well, let me ask, I'm in all trouble with the court, we're going to take you. Would you be available for trial on 8/31 with your motion hearing?
I am, my calendar is free on August 31st and August 28th. However, my client, as I understand it, insists on an August 28th trial.
Well, since your motion was filed late.
Yes, sir.
Then I'm in a position where, well, I'm trying to give it a trial as quickly as I can. Push the trial to the 8th. And I can have a motion submitted, you can be prepared. And you will not be delayed significantly. I think that's why we can kind of speed trial.
I understand what the court's attempting to do, and I appreciate its efforts.
Davis, you want to say something?
Yeah.
My understanding, you're insisting on an August 28th trial.
Yeah, can I elaborate, explain?
You can elaborate on it, yeah.
I may need a piece of information. When does 180 days run?
Well, that's what you
basically 6 months from June 14th.
Yeah.
December 14th.
June 14th, yeah, December 14th.
That's when your 180 days runs.
I pled not guilty January the 3rd. The court asked me, I pled not guilty January the 3rd and said I wanted a jury trial, so I don't understand what's going on.
Well,
Perhaps the court can inform or educate Ms. Davis. She thinks she pled not guilty on January 3rd.
let's, for the sake of argument, assume that that happened these days. The period of time when you were found to be incompetent does not count for that because you could not make a trial in this period. And that period,
I think they gave, the court, the 46 days, from June, from April the 19th until, June 16th or something. Calculated to be 46 days, there was, they had extra. Yeah, all that time added up to be 40-something days, they had to take in trial.
That's from the first finding of incompetence,
Yeah.
which dates back further than that.
The judge said on April the 19th, starting, the counsel said until I was released and head back to court in June.
okay. Ms. Kuykendall submitted her report to the court on January 25. And the court, following that, made a finding of incompetence. And then there was a subsequent report from Mr. Appel, Dr. Appel, that was not that was the defense expert, and he concurred in this Kuykendall report. And then finally, she was restored the competency. I'm sorry, Ms. Kuykendall's report was filed in report on February 7th. And then, that's her second. And then,
Excuse me.
Mr. Atwell, Dr. Atwell's concurred, and then she was restored to competency. And that was restored to competency in June. So between February and June, that period of time does not count for the period for the calculation of speedy trial, even if on January 23rd, the national period was
Oh, I was going from the date, the judge gave, April the, 19th, and he counted up until June, I think it was like 46 days.
It was from the finding of incompetence until June.
That's what I was counting as the extra days that would be allowed from so, that's, what I got from the judge.
between February and June,
So we're back to where we were.
that we are well within speedy trial, even if I'm not going to do it on January 3rd.
Yes, sir.
We could argue.
Yes, sir.
So I'm still offering you to go with that option.
The option of having the motions hearing on the 28th and the trial on August 31st.
Whatever you guys say.
Can the people do that?
I believe so. I will note, I haven't seen any indications that the Todd trial will not be going. Mr. Corley and I did some impasse probably 2 months ago, and it's my understanding that they intend on going to trial. But if the court would prefer to move that,
I would
I believe that I would be able to get them to hear the next date.
And this is process because the payroll is 40/30.
What's your question? I don't negotiate with the judge.
That's my hand.
Cap was 12 months. It would be an additional 6.5 months to get credit for time served. No, it would be time in jail.
Oh, okay.
No probation. At the end, you'd be done.
No, I just wanted to know that. I just had to clarify what the offer.
Well, that's what the first thing to do, is to do that.
So, summarize, hearing motion is August 28th, trial is August 31st.
9 o'clock in the morning, on the 28th, expected every morning.
That's fine, Your Honor.
Very well, I think we're done for today.
Thank you, sir.
You're welcome.
So when do you want to get together and discuss these videos, witnesses that I want to call or whatever, how you want us to get that? In a few minutes. Thank you, baby. Give me a few minutes.
I need to see this video.
I'm gonna send it to you. I got your email address. What I'll do is I'll go to the hotel. And the first thing I'll do is email you this video. Let me see anything. Let me see anything. He didn't set a time for the trial to start?
I think it starts at 8:30.
Is it the trial?
Yeah.
Good, let me write that down.
I think. What did I put down in my calendar for the 28th?
Okay. Yeah. When do you want to get together to discuss this evidence and,
I'm just down all that. Let me look at my calendar. I've got people howling at me. August 1st. When's good for you? I have a trial next Tuesday in Park County.
Okay. Anytime, you just give me a call and, I have to try and, get around here.
You're gonna stay in town until the 31st?
Am I allowed to leave?
Nobody, I'm not aware of any constraint on your leaving.
Well, that's what the motion you were supposed to file, and that's why I had to bring this death certificate.
The court, when
They had
when the court sets a trial,
Mhm.
it sets a plea cutoff date.
Mhm.
It's mandatory that the defendant be present for that.
Okay.
There's no opportunity.
The paperwork that they had me sign saying I can't leave the state, and I have made them, I got the copies because I wouldn't sign that because the sergeant arranged for my Greyhound to be picked up in front of this jail. So they tell me, the paperwork saying I can't leave the state.
Then you
So-
can't leave the state, so you're gonna be in town, okay.
I can't afford to stay. I'm going to Grand Canyon City, a shelter. I cannot afford to pay $75 a day. I only get so much money a month, and that's going to leave me broke. I won't be able to eat. So no, it's not. This is not helping.
Have you got your laptop up and running?
Yeah.
You've been able to view the video on it?
Yeah.
Have you been able to view the phone video on it?
I used to download it. I've seen the phone video. It's on.
I just want to know whether
Yeah.
I need to be in the company of your laptop in order to see it.
I'm going to email you this.
Right, then I'll email it. You email it today. I'll get a chance to see if I can review it,
Mhm.
and then I can give you a call and see if we need to get together.
Okay.
Because otherwise, there's one fundamental question
Mhm.
you need to answer,
Which is
and you don't need to answer it today.
okay.
You can answer it in the middle of trial.
Okay.
Are you going to testify?
No, I don't intend to say anything. I don't want to say anything. I don't intend to say anything. Don't expect me to say anything. I think the videos are going to speak for me.
Well, everything depends on how clear this phone video
Right.
is.
It's clear. It's loud. It's going to rock the house in there. So,
All right. Then we don't need together. You just need to be back here on the 28th.
whatever you say. Whatever you say. I'll go home and email you this right now. So you'll get the email before the night, even if I have to go to the library and email it.
Okay, I've got other clients coming for my attention today.
You can't use everything up on me. Thank you, man. All right. Thank you, sir. You too, man. You too. How's your wife? Okay. Watch the video that I told you about. Did you watch the video? Okay. Make her watch it and don't give her none. That's how you make the ladies do right here. Thank you. Okay, Randy, I'm waiting to hear from you. I can't call you because my phone, it's going to be a couple of days before I get my new phone, and I'll give you another number.
Well, the only, as we approach the trial.
Yeah. How much, they trying to have me serve 6 months and then another 6 months in jail? Is that what he was trying to get me to agree to? I'm not trying to agree to go back in there and do no time. And this woman that beat me and admits to beat me ain't there saying a day? This don't make no sense. This is the reason why I don't want
to repeat his offer?
This is the reason why I don't even want to say nothing, because there's no law. This woman admitted to beating me and ain't been locked up. What the hell I got to do?
You have to make decisions with what's in front of you.
Well, I'm just saying, she admitted to beating me and ain't been locked up, but that just tells me.
That's part of the case.
It is.
Unless you plead self-defense.
Well, I'm going to plead whatever you say. So work that up and write it up, whatever you say. Whatever you say. I don't have to, it just don't make no sense. This really just don't make no sense. This tells me that there's no law. You want me to do time, but you ain't even trying to press charges on this woman? That's the district attorney. No, the district attorney want me to do time, but you ain't locked up.
He doesn't even want
Get all criminals off the. He don't want me to do no time. I've been locked in this hellhole. They took cards that made me a hole, Randy. I've been beat and then tossed in a hole.
He's leaving sentencing open.
So what? So the judge can sentence me to 4 years?
No, with a cap of 12 months with credit time served, which means a cap of 6.5 months.
I'm done 6.5. I've been locked up since January.
That's the max you'd be looking at.
Well, so tell me, write that down. Put it in writing. How much time he wants to give me? I deserve 6 months.
He's told me. I've told
you. He told you what? So he wants me to go back and do another 6 months in jail?
Up to.
I'm not, If I'm going to do some time, if I'm going to do some time, let the jury convict me, and then I'll go do the tax. That way I can appeal.
Then it's up to the judge.
I understand.
Judge's decision.
I understand.
What he's doing is he's leaving it open to the judge.
I understand.
Well, if you are comfortable with your chances in front of the judge.
No. He lied to me, Randy. You know he lied to me. He told me the only way I can fire you is to hire another attorney. He appointed you. He has to fire you.
He signed the order, but...
You understand what I'm saying? He's lying to me. He's not going to be fair to me. He's telling me he can't even be impartial.
The offer you've been given is...
Tell him, write it down.
In a better position.
Write it down and email me.
It's too late. Today's...
Oh, okay, well, yeah. Man.
Today's cutoff date.
Hey, and the 27th of the day. Hey, thank you. I got it all over, all paperwork and everything. Thanks, Randy. I'll be looking to hear from you. When I get another number, I'll call you and give it to you. But I'm gonna email you. Shit, I seen that video. You can see my goddamn gun. That cop is flat out lied.